Yeah. Today, actually, we are blessed to have you all here, a group of international lawyers, and I'm so honored to have this webinar to address some of the biggest issues that we are facing nowadays, which is, as it says, the title, the impact of COVID-19 on the development of law and on the work system in the law firms and courts, and a global view. We can take like cons and pro-cons, the negativities and the upside of it, either locally or internationally. And that's why we have this meeting here or webinar here today, so we can at least compare and see in each country. With us, like in Kuwait, Mr. Abdurrahman Al-Tahous will address the same issue, and I'm gonna address the same, the same question to him in Arabic, and he will respond to it. So we'll start from here, and I'm gonna ask the same question to Mr. Abdurrahman. أستاذ عبد الرحمن كيف الحال؟
حياك الله، يا هلا والله أستاذ محمد.
شلون أموركم؟ طيبين إن شاء الله. أستاذ عبد الرحمن
فيكم.
الله يحفظك، مشكور على وقتك.
انتم اللي مشكورين، وبالفعل يعني هذه نفس هذه الامور وهذه المواضيع يعني تثري عملنا كمحامين، ويعني نستفيد من خبرات زملائنا المحامين من جميع انحاء العالم ان شاء الله.
نعم. استاذ عبد الرحمن، نبي من نظرة محلية حاليا داخل الكويت، شنو منظورك بخصوص الكوفيد 19 وكيف كانت آثاره علينا كمكاتب محاماة أو كالعمل القانوني أو بتطوير القانون بشكل عام أو في أداء واجباتنا في المحاكم؟
بسم الله الرحمن الرحيم. طبعا هذه الجائحة يعني نتمنى إن شاء الله تعدي في أقرب وقت ممكن، وإن الجميع يتعداها بسلامة وخير. من بدايات جائحة كورونا اللي هي كوفيد 19 أعتقد أن اكتشفنا الخلل اللي موجود في أجهزة الدولة، بما يعني اللي احنا نتعامل وياه كمحامين. أتكلم عن وزارة العدل والوزارات الأخرى والمحكمة اللي مرتبطة في عملنا فيها. أعتقد أن يعني سوينا كيف تسلل عن بعض الأمور اللي احنا بالفعل نفتقدها، وكذلك يعني أنا أعتقد أن هي جائحة، ولكن يعني اكشفت لنا بعض الأمور اللي خلت الدولة مجبرة أن هي تعدل وتطور النظام أو الجسم القضائي بما يعني يخدم هذا التطور الحاصل في جميع دول العالم. بداية طبعا احنا في جمعية المحامين كان يعني لنا نظرة وكان لنا تصور في تعديل بعض القوانين الملامسة لعملنا المباشر، اللي هو في قانون المرافعات وقانون العمل في القطاع الأهلي. في أمور يعني تم تعديلها بمساعدة إخواني في مجلس إدارة جمعية المحامين. تقدمنا طبعا بطلب بتعديل هذه القوانين وشاركنا في تعديلها. من ضمنها أنا أعتقد الأمر اللي جدا مهم اللي هو الإعلان الإلكتروني. هذه يعني كان من المفترض أن يعني صار لنا مدة أن احنا مجتازين ومطبقين النظام الإلكتروني في الإعلانات، ولكن يعني الجائحة هذه خلت أجهزة الدولة مجبرة أن هي يعني تنفذ هذا القانون، وهذا طبعا راح يعطيك سرعة في التقاضي وسرعة في التعامل مع الدعاوى في المحكمة. بالإضافة إلى كذلك هناك قانون القطاع الأهلي وقانون الإيجارات، ويعني العديد من الأنظمة كان لنا مشاركة فعلية في جمعية المحامين في تطوير هذه القوانين وإضافة بعض المواد لهذه القوانين. منها يعني أنا أستذكر اللي هو قانون الإيجارات. طبعا أنت اليوم في أثناء الجائحة هذه يعني تضرر العديد من المواطنين والمقيمين في دفع أجور يعني محلاتهم المستثمرة أو محلاتهم المؤجرة يعني بقرارات من الدولة. لذلك الدولة يعني طلعت بعض القوانين وشرحت بعض القوانين اللي احنا شاركنا فيها، اللي هي أثناء هذه الفترة يعني ما يجوز أن للمؤجر أو لصاحب ملك الاستثمار أنه يخليك في أثناء هذه الفترة إذا أنت ما دفعت الإيجار أنظمة معينة تم وضعها. وكذلك يعني في المحكمة أنت عارف في مواعيد هنالك لرفع الدعاوي وللطعون في الاستئنافات والتمييز. كذلك قرت بعض القوانين وبعض التعديلات اللي من شأنها أن أثناء فترة وقف الدولة يعني لأي سبب من الأسباب تترحل هذه جميع المواعيد، تقف عند آخر يوم وقفت فيه وتستكمل عند أول يوم من بعد قرار مجلس الوزراء. كذلك في يعني المحامين والمحاميات في جهة أخرى يعني المتضررين من هذه الجائحة بعدم إمكانيتهم استقبال موكلينهم، عدم إمكانيتهم إنجاز أعمالهم. اليوم أنا أعتقد صار في نقلة نوعية يعني في مكاتب المحامين أجبروا الكثير والعديد من المحامين باستخدام وسائل التكنولوجيا الحديثة في عقد اجتماعاتهم، ويعني كذلك يعني الحضور مع موكليهم في الوسائل الإلكترونية. أصبحت الأعمال تنجز بشكل كبير. يعني احنا شويه متاخرين، يعني خاصه بالكويت احنا متاخرين بالجانب هذا. في دول عديده سبقتنا بالجانب هذا. احنا لازلنا نطبق النظام التقليدي في العديد من مكاتب المحاماه، انا اتكلم المحليه. فاجبروا ان هم يتعاملون مع وسائل التكنولوجيا، وهذه انا اعتقد يعني فيها نقله نوعيه للمتقاضين وللمحامين ولجسد المحاماه بشكل عام. كذلك كان يعني طبعا احنا طرحنا الموضوع هذا بندوات متواصله وبعقد مؤتمرات الكترونيه وضحناها لجميع المحامين. ويعني انا التمست ان العديد من المحامين يستخدم النظام الالكتروني بالفتره السابقه. كذلك في يعني نقطه مهمه احنا سعينا فيها منذ بدايه جائحه كورونا ووقف الاعمال المحاماه في الكويت وغلق المكاتب. سعينا مع مجلس الوزراء وكان لنا عقد اجتماعات دوريه مع مجلس الوزراء. يعني وضحنا من خلالها ان المحامين يحتاجون هذا الدعم، عندهم التزامات، عندهم، فاصبحت هناك يعني دعومات من الدوله بالنسبه للباب الخامس اللي هم اصحاب المحاماه، وكذلك للباب الثالث تم صرف يعني راتب 6 أشهر بمساعدة يعني العديد من جهات الدولة، مجلس الوزراء ووزارة المالية، وكذلك دعم العمال. هذا باختصار يعني ما قمنا فيه في جمعية المحامين. وأنا أعتقد يعني ختاما ما نبي نطول، أعتقد أن جائحة كورونا خلقت العديد من المشاكل يعني لدى الشركات ولدى الأفراد. فلذلك أنا أعتقد يعني بجانب آخر بعيد عن التطور اللي وصلنا له في هذه القوانين، أن أعمال المحاماة راح تنتعش بالفترة القادمة في جميع دول العالم. أنا ما قاعد أتكلم فقط بالكويت. أعمال المحاماة راح تنتعش يعني لأن هناك العديد من المشاكل. يعني بدأت الشركات قاعدة تفلس، المشاكل بدأت تظهر بين المتعاقدين. فلذلك أنا أعتقد هناك انتعاش
يعني أستاذ عبد الرحمن، النظرة الإيجابية أكثر مما أنها تكون سلبية، خاصة في مجال عملنا في كمكاتب المحاماة.
بالضبط أنا أخص في مجال المحاماة. هناك انتعاش للسوق في الفترة القادمة.
الله يعطيك العافية ومشكور أستاذ عبد الرحمن على هذا الطرح والإطراء الجميل. In a brief, I just want to translate what Mr. Abdurrahman said, so we can each one of us take your time and explain the same issue and topic and their local and personal view. What Mr. Abdurrahman says that the COVID-19 actually affected us in the short term for now, but the whole point of view is actually really positive, especially for law firms right now. Not in a good humanitarian way, we said that the problems for people actually increased in this pandemic, either rentals or financial. So that actually gives more and more, let's just say, contracts and jobs for each law firm, and the role that the government actually plays in this pandemic, that's what affects us, and in court or as law firms. So I just actually want to hear, Mr. Andre, your point of view and the way. Would you open the mic for Mr. Andre? Your point of view locally, and then we can actually compare in a global way. So, Mr. Andre.
First of all, thank you very much for this invitation. I'm very pleased to be here and to see my colleagues. So have a good day ahead for those who are in the Western Hemisphere, and for those who are in Europe and Asia, have a good night. Can I use my slideshow right now, or do you want that I express only a short opinion on what is going on, or resume of what I understand the situation is going on right now?
Yes, actually, I want your opinion, and as it says, the importance of and how the electronics now. Actually, in Kuwait here, we are a little bit, and unfortunately, I have to say that we are a little bit late on the electronics and the conference cam meetings. That we don't.
Okay.
We are forced to do so right now. And also, I want to raise another questions for all of you, please, and anyone would like to answer.
Thank you.
Let me know.
Thank you.
Yeah, so I'll give you my question later on after you explain, Mr. Andre. Thank you so much.
So that's correct. We are facing a very difficult time this century. I mean, probably this is the most difficult crisis that we are facing in the 21st century. And this is, I agree completely that at this moment a lot of work is for lawyers, but our practice is being really it has been we have a lot of challenges as well, and these will be challenges for large law firms, as I believe, because due to communications and due to technical, the hierarchy in the large law firms. And as for me, I have a small law firm of myself. I have few assistants, and I work with them distantly at this moment. If I can speak about Russia. At this moment in Russia, all courts are open, and the only measure that we have to comply with is wearing masks. It was only until the end of May when we had to wear, when we had to be to communicate with courts, distantly through teleconferences and so on. So the major impact that COVID-19 had on Russia is not in procedural laws, but in substantive laws. And I prepared a short of kind of presentation, but I can, relate it in my words. Not in terms of procedural laws, but in terms of substantive laws, because of great measures, very significant measures being taken by the Russian government based on delegated authority from the legislature. And it is really unprecedented, huge grant of power for the government. And at this moment, I have a case in the Supreme Court in Russia against the Russian government and representing consumers who believe that the grant of authority has been significantly exceeded by the government, who promulgated certain regulations which frozen payments to consumers for up to 18 months. Wow. So these are really significant measures, and yes. I believe, as for my country where I'm currently now, the most serious impacts are not for the mechanics of courts. Because I look how American courts work, and I believe that the American courts, in California courts and in Russian courts work the same way, approximately the same way, because I receive newsletters from both courts, and where the most significant impact lies in is the substantive laws and the great grant of authority that the government is obtaining in many countries, including Russia. And this is the sphere for discussion, I believe, this time. Thank you.
Thank you so much, and I really appreciate that. Mr. Babu, I do have a question. Do you think the consequences of the electronic court system, does it have more negativity or positivity in it? And especially right now, like here we are facing in Kuwait, the way we approach the bench, it's kind of also different. All judges and owners, they don't even want to reach for the documents. They don't want to even get near us whatsoever. Right. And we don't have like the in United States system, like somebody will take the documents. No, you have to deliver it yourself. So this is one of the problems that we are actually facing. And some actually of the judges not just won't allow you to approach the bench. You cannot actually go inside the room unless your number is up, your roll is up. Right. They will call you outside. So what about the consequences of the electronic court system? I just want to hear in a cons and pro cons way. So
contrary to what Andre said, the situation in India is very different in the sense that our courts are not functioning. We are only allowed to appear through video conferencing. And before we're given a hearing, we have to make out a case for extreme urgency in the matter. Otherwise, the courts are virtually not functioning. So there is no question of us being in court to be able to apprise the court of an urgency in a matter in person. And where before we could get a matter listed on a day's notice, now we need a minimum of 72 hours or 48 hours to get a listing done, even in the most urgent of cases. But when matters do get listed and they are heard through video conferencing, the hearing is very smooth. The technology that the courts deploy is very efficient. We are required to file everything as a soft copy. And the soft copy is with the judges, and there is a system for cross-referencing, so the judge knows what you're reading and is able to follow up with you on that. So once we manage to get a matter listed, we find that the hearing goes on pretty smoothly. And in fact, I feel like that is a very positive thing, because a big part of the Indian court system was that we had to go and wait for our matters to be taken up on a particular day. So if I know that I have, let's say, 7 to 8 matters a day, which is very normal for an average Indian litigation lawyer, I don't have a time frame within which those matters will be heard. Like, I don't have a slot. I just have to wait the entire day, and when my turn comes up, it comes up. But now I'm able to conduct a hearing from wherever I am, as long as I have a stable internet connection and a video facility. So that way, it's much better. But we still have a long way to go in terms of capacity addition. Whereas courts would take up about 100 matters a day when there were physical hearings, now they're not able to take up more than 20-30 cases. So access to justice has become a bit of an issue unless you're able to show urgency. Yes, in cases where there is urgency, like bail matters, where people are threatened with imprisonment and they have to obtain bail, or cases of eviction where people may be thrown out of their homes, courts are functioning for them on a regular basis. But in most commercial disputes and most disputes of any other nature, unless we're able to show urgency, it's very difficult for it to get listed. So I think these are some of the teething issues that any system will have, because all of us have had to adjust very quickly to this, and none of us have had adequate notice to sort of adjust to this new system, whether it's the court or the administrators who run the courts or the lawyers. So I think as long as these issues get resolved, e-courts and virtual hearings are better for us as lawyers.
I see. Well, in some way, actually, Mr. Babu, I really do envy you for the trials that you have. You have your hearings over the online, which we don't have so far, which is unfortunate. But thank you so much. I really appreciate your participation with us, and I really got more information with that. Mrs. Christina, hello, hi, and how you doing? Do you have the mic on? Oh, okay. All right.
Yes, now it's working. Good night, Mr. Mohammed. Thanks for the invitation. I'm very pleased to be here.
Likewise.
with pride, and seeing my former colleagues from Berkeley. I'm very happy to see all of you.
That's awesome.
The situation in Brazil, it's peculiar in the sense that for the last years, we are going through a process of creating virtual actions. Like the judicial actions, they're not paper anymore. If you start a claim in the court, you're going to do everything through a system. We still have a few paper actions still in the courts, but that's a very low percentage. So that process that started around 8 years ago, started from the superior courts. Now it's heading more to the states. That process really helped with the COVID-19 situation, because we were able to still keep the process moving. However, in the beginning of the pandemic, we have a National Justice Council, and they decided for around 35 days suspended all the deadlines and the countings of the any motions you apply and presented to the court. So from March 25th until April 30, all the courts in Brazil, they weren't accepting like motions or any types of appeal. So they gave this period of time for the lawyers. I think in Brazil, we started thinking that will be only a month situation, 2-week situation, and then they decided, the National Justice Council, to stay put, and only urgent matters, there will be trial, like they would accept the files. They would accept the trials, but the deadlines wouldn't count. So they sort of gave like this huge vacations to the lawyers in a way.
Yeah, I see. Yeah, we got the same. Yeah.
Yes. And then since we already had this situation of moving the court, the actions to a virtual sphere, it really helped. And the courts started having also the hearings and the trials. They're all through Zoom, actually, platform, exactly like this. So we see the trials. Actually, our Supreme Court in Brazil, everything is the major college. They have two different colleges, but the main one, it's open to the public, and they even put it on YouTube. And that's something we're doing for more than 10 years now. So in the Supreme Court debates, everyone can listen, and it's actually something very interesting in Brazil, because sometimes when the justices, they disagree, it's record and everyone is watching and everyone is talking about. So it's very open, it's very public. And what they did, they actually got this platform. Actually, everyone is doing through Zoom, and all the hearings and trials, they're actually being done through this platform. So the lawyer, he just, if it's his action that it's being trialed, he just sends an email and said he wants to do his oral arguments, and they created its line, and then they have the oral arguments through everything in the platform. The courts, at the beginning, everything was closed. Now, depending on each state of Brazil, it's actually reopening. I'm actually from the federal district, so here we're still in the uprising contamination. So the local courts are not working. The Supreme Court, the hearings, every justice is in their house, and the Chief Justice is the only one in the court. Sometimes there's another justice too, but mainly it's just the Chief Justice in the room, and all the other justices and lawyers, everyone is individually in their house. But the courts, and in principle, all the courts are closed. In some states, they are reopening. Actually, here in the federal district, they're going to start reopening next month. So every procedure you have, if you need to do a hearing with the justice or the judge, you send an email or a WhatsApp. Actually, some cabinets, they're giving their WhatsApp.
I'm envying you right now.
Yeah, some clerks, they put the WhatsApp number of the cabinet, and you send a WhatsApp, and you can do you can ask for information, and everything. It really depends on the courts in the state, and it really differs that moment. And actually, what I believe in Andre mentioned here in Brazil, I feel we have sort of that feeling with the law practice. I think João will talk more about that, but we are feeling that the litigations are going up, And actually, the way the court is working right now, they're producing more. The productivity went up with the home office situation, and everybody is complaining way more that they're working like the whole day. You wake up and you finish. You don't have a break. You're working the whole day, and so that same factor happened in the courts, and we could see that there are way more volume of decisions and hearings, but the quality went down. Like, as a lawyer and watching the decisions that are arriving, and I'm actually really impressed with the quality, and I'm working way more as a lawyer because it's so absurd, the things that I'm reading, that I have always to present an appellation and, a motion against certain decisions. So the reality in Brazil, it's positive because we had this process of changing everything for the virtual area and having a platform for judicial actions. So that really helped in this process, because the paper actions they're still running in the courts, for a period of time, they were suspended because they didn't want people to change touching the same things. So, but the virtual process, the virtual actions, they kept going. And now this is where we're heading. Now the courts will start to reopen, but it depends from each state.
Oh, I see. That's actually really amazing. And with us, it's slightly different. And well, I can say more than slightly different. It's an easy way for, like, we have reopened everything, but the amount of work they allow us to do, it's actually really, they give us the minimum. And that's why we are a little bit struggling about it. And we are just kind of confused, in the confusion area right now, in the confusion period, because you have your all claims that before, and that everything stopped for almost like 3 to 4 months. And now they reopened everything, but not at once. They kind of arrange it a little bit, like from 30% to 50%. And now that everything's so loaded in most of law firms that they cannot even take a breath, if you know what I mean. And it's just too much pressure. So,
and if I can just compliment another thing that you mentioned, sir, here in Brazil, also when we have private hearings, we have the public ones, the trials, and sometimes public hearings, depending on the kind of action you're moving. But we have also private hearings with the justices and the judges. You can ask in the agenda in the cabinet to be seen by a private individually by the justice, and that really helps in the process, because then you bring a memorandum and you explain the case with more time to each justice, and that's a possibility that it's not really happening when they're not actually having more space. They don't give any more time in the agenda for lawyers. And they actually just asking for you to send a memorandum through email. So you're not really sure if you're getting or reading or just throwing away. So in a way, that's complicated. Like, the volume of work, it's higher, but the quality and how we're actually reaching the court, it's being very difficult. We don't know, actually, I think it's the viable way of doing this, but it's very hard to practice when you're not actually looking someone in the eye and know, like, about the information that you're requesting, giving your memorandum to at least to the clerk for the justices. So that's being a challenge here.
Sure, I see.
In the practice.
Well, thank you so much for your comments, and it's actually, I learned a lot, and now I kind of want to move to Brazil to practice law over there for a few months and then come back.
You're very welcome.
Thank you so much. I really appreciate it. Mr. Joao, if you want to keep on and continue, or I do have a question, but this question that I have, I want to just give it to all of you, but I just want to postpone it to the end. So, Mr. Joao, let me just hear your point of view, and let us actually all hear that. Thank you.
Well, after Christina's brilliant explanation about what is going on in Brazil, in the courts, and how did the courts adapt to virtual hearings and everything, I don't think I have much to add there. But speaking about the impacts in general to law practice and the firm, being a multi-service firm, really helpful during these times, because your firm can rely on the for instance, on the growth, the work for litigation department, labor department. So we have these different areas that balance each other out. In my practice, which is more corporate, actually I'm a banking and financial regulations expert here in Brazil. So in my area of practice, we were monitoring other changes in terms of legislation and other types of changes that are being implemented and in a certain way fostered by the government. So if you allow me, I would take a more kind of economic and policy approach to what happened in Brazil. So basically, what Christina mentioned about the digitalization of some public services, so which has been going on in Brazil for a while. This has been expanded to other areas, and I think that one of the benefits of this pandemic, can even say that, but it was that some of these digitalization processes, they were expedited. So some changes that were being kind of held up in the past, they start to move faster, and especially when you take into consideration corporate and financial aspects of the law. So Brazil is known for its huge bureaucracy and lots of red taping, right? When you want to open a business, open a company, or close up a business, or do all sorts of corporate transactions, everything is very bureaucratic. You have to go through a board of trade and register all the acts. So it's very cumbersome for companies, especially small to medium companies. They have to deal with all this bureaucracy. And I'm not going to not to take too much time. I have a presentation I can share with everybody later, so you can see the details. But basically, there was a huge amount of flexibilization in terms of the requirements, the formalities with respect, for instance, with corporate acts. So ability to hold general meetings virtually, and that becoming acceptable in general. Little things like that really made a big difference, and this there's a huge list. And in terms of policy also, there is in Brazil that I would like to highlight this big effort by the Brazilian Central Bank to really push forward, and the Central Bank was not paralyzed by the pandemic, in the sense that it continued to move with its reforming agenda and modernization agenda. So in Brazil, in the banking sector, Central Bank continue with initiatives like implementing faster payments or instant payments to the general public. So Brazilian banking system is really technological in the sense, and it's technologically it's even more advanced than some developed countries. And then, of course, there's a reason for that. After so many financial crises, the financial system had to adapt and become faster and more competitive. So, but the central bank really continued with this agenda of reforms. And basically, what's been on the central bank's agenda for a while is the issue of inclusion in the financial system, right? So in Brazil, we have a huge amount of the population it's unbanked, which means that they don't have access to financial services.
Yeah.
So the latest research polls say that around 45 million Brazilians, they don't have access to banking services. And on the other hand, you have a huge banking concentration. So you have like 4 or 5 banks that hold like 70 to 80, sometimes 90% of financial assets or credit, right? So so the credit doesn't reach the regular individual at the end, especially if this individual is not in a big city or if it's economically handicapped, let's say, and socially. So the central bank has been putting this effort to reverse this situation, this scenario. And it didn't stop during the pandemic. So we have things like, as I mentioned, the faster payments, instant payments. This is something that is very important here and is going to change the payments, the electronic payments landscape here in Brazil. We have the open banking initiative that's been implemented also here in Brazil. So allowing clients to share their information and share access to their own data and transactional capabilities to other financial institutions. So the client now can have more options to use and adopt financial financial services. And that became a huge issue because one of the main things that happened here in Brazil was the issue of the financial aid or the pandemic relief funds that had to be distributed to the poorer part of the population. And how can you make that money reach these people if they don't have bank accounts, if they don't have credit cards? So there was a huge effort by the government and some public banks to create alternatives to make this money go to these people that were really. So remember, 45 million unbanked people. So this is it was a huge challenge. It worked until a certain point, but the gap is too broad still in Brazil. But definitely there was some speeding up in this process during this period. And also in recent years, Brazil enacted a labor reform that, in my point of view, helped a lot during this pandemic with the unemployment that rose a lot, because the reform provided a little bit more of flexibility into the labor for the labor relations. So during the pandemic, what we could see is that companies that were going bankrupt, or they were not bankrupt, but they were facing financial difficulties, they were able to pay half of the salary, and then the employee could work half of the time, and other combinations that allowed a part of the population to keep their employment. And that was only possible because we flexibilized a little bit of these labor regulations that were much more strict and gave very little room for this type of arrangements and negotiations between employers and employees. So being very fast in this first appearance, I think that this is a little bit of what was going on in Brazil and still going on in Brazil. Some things improved. The digitalization processes really sped up a little bit, but I think we still have a long way to go. And I think the technology has gained a very important role in all this. Everybody is really looking to technology as something that is vital for the country to succeed.
True. Thank you so much. And I really agree with you that the governments actually right now, they are really playing a big role, and especially with us here in Kuwait, we really got financial support and all kind of support, to be honest with you, with the governments and the royal family, just to keep up with those private sectors that they went down really quick for the entrepreneurs, the small companies that it's barely was starting up. And for each, like, let's just say, law firm leader or owner of a law firm, the government really supporting them financially in every way possible, just to keep up with the downturns that we are all having right here. Thank you so much, Mr. Jawal. Really appreciate that. Mr. Isaac, how you doing, and how is everything with you in the United States?
Well, doing okay, all things considered.
I see. Thank you.
Well, I guess
I will tell you one thing. I'm not going to talk about the elections in the United States right now because I'm not going to go into that. I just want to, actually, I do have a question right now, and it's kind of also in a financial way. Right now, with the crisis that we are having, I would say worldwide with the Covid-19 and especially with law firms, do you think whoever who has the individual law firm, the one-man show law firm, is better for him now to partner up, to have a partnership? Because this is the direction I just want to talk about us in Kuwait here. We have, especially those small law firms, really struggled in the beginning, and now the direction they are going from individual law firms to no, I wanna partner up with somebody and make like a small company, or at least just to have a partnership so everybody can pick up the other one. So what's your point of view on that, Mr. Isaac?
Well, thank you for the question, and I think it's a very good one. I think it probably is certainly the wave of the future to some extent. I know lawyers here in the United States, and St. Louis, where I'm coming from, in the Midwest. So from the Mideast to the Midwest here.
Yeah,
and,
I see that.
And I do know some solo practitioners or very small firms that have started to kind of merge or at least cooperate with each other. They're kind of sharing their resources and their expertise and know-how with each other, because it is, of course, very difficult, as other people on the panel certainly can attest to as well, for one person to do everything. I mean, I know that from personal experience before as well, let alone now when we're very much restricted to home. And so I certainly see that as a possibility moving forward. If I could, what I did want to kind of, though, return to, if that's okay with you.
No, please, no, that was just a question, and please, I want to also talk about our main topic, how the impacts.
Sure. So, but thank you for the question. So that is a good point, and it probably is going to be one of the indelible effects of this pandemic. I did want to reiterate what other panelists have said. Certainly, the lack of the contact with the clients, probably, and to how do we engender trust with them when it's very difficult to look them in the eye, is also very frustrating for practitioners. But probably the greatest challenge that the American judiciary, that our legal system faces with this pandemic, is the right to trial by jury. It's such a rarity, right, in the United States, when we select 12 random, ordinary, everyday citizens.
12 angry men.
12 angry men, well, now women.
And, just a reference.
Exactly, but right, great movie.
Yeah.
It's always ubiquitous on Law and Order. How do you get them in the room? And they're supposed to be the fact finder when particularly in the criminal case, when the prosecutor and the defense will present their evidence, their arguments, and these jurors are supposed to retire to a room where they deliberate, right, and ultimately decide the verdict of guilty or not guilty. And I can tell you that other things like motions, pleadings have gone remote in courts across the country, even in the criminal side of things. So bail hearings, plea bargainings, sentencings, but the trial by jury has virtually halted, because it's what's really unique to the U.S. is this right to trial by jury is enshrined in our Constitution. And so the Sixth Amendment in the Bill of Rights guarantees every defendant the right to a fair, impartial, and speedy or timely jury trial, including the right to confront his accusers or cross-examine witnesses. And so the real issue is, how would this be done remotely, especially if the technology potentially would freeze or there would be outages? That's one concern. The other concern is, would it violate the Constitution if the defendant had to confront his accusers this way? There's been no lawsuit filed as of yet, but I certainly foresee that as a possibility if the courts continue to be shuttered in many states, as they are. The other thing is, the jurors are supposed to assess the credibility of the witnesses or of the defendant when they testify, looking at their demeanor, their body language, right, how they respond under a barrage of questioning. And so this is all going to be really difficult to do, probably on a remotely based platform. The other issue I should note, which was a shocking statistic to me, although perhaps it shouldn't have been, is there's a report from 2017 where the Federal Communications Commission, or FCC, noted that 20 million Americans lack access to high-speed internet. So even if we wanted to do it remotely, it would be so difficult to do it if these jurors are going to be at home and don't have access to the internet, or it's extremely slow and can't sustain the bandwidth to have a trial going on. So that's the concern with doing that remotely. On the other hand, though, if we wait for the courts to reopen, as they gradually are in some states, although I think, as Christina mentioned, it's really on a state-by-state basis. The longer it waits, though, these trials are being postponed now by a year or two. And so that's a denial of justice, potentially to the defendant for their speedy trial. That would also be a potential lawsuit. But also, it could be construed as denial of justice to the victim, that they're going to have to wait now for a year or two. And are they potentially going to take matters into their own hands, a la Batman, and go vigilante? So there's a lot of issues at stake either way, if we try to do it remotely, if we don't. And it's certainly a novel situation, but obviously these are unprecedented times. And she said the greatest challenge that we're facing, at least in a century, since the Spanish pandemic of 1918. So, but I hope I've kind of summarized this. And
you actually did, and thank you for the other reference that you just did. That actually made my day. And the other thing is, I graduated from United States, and we did a mock trial in Santa Clara University, and I was one of the jury. And I'm not gonna lie to you, Dr. Isaac, I couldn't be more confused, to be honest with you, because with us we don't have that kind of system here, and we don't have it anywhere, especially in the Middle East. And when I went there, the first thing they told us that, first of all, in this class, you need to watch 12 Angry Men. And I said, okay. And then I just wanted to see the point of it. And after that, they did the mock trial. Thank God we won. I cannot even, I vaguely remember that. But it was also shocking to me, the system, how it works and how different it is culturally and everything. So thank you so much. I really appreciate that, Mr. Isaac. I really appreciate it. Now we're moving to Dr. Alvaro.
Hello.
Hello, how are you and how you doing?
Good, good. I greet you here from Italy at the moment. Although
that's awesome.
Colombia. Yes.
Dr. Alvaro, if you already know the topic, and if you just tell us a little bit your point of view, the way it's going on in Colombia or in Italy, if you like to. So just please don't hold back.
Thank you very much, and thank you to your team at the Kuwait Bar Association for the invitation. I'm enjoying very much learning from my colleagues and seeing them again. I want to touch a little bit on insolvency law and the reactions that the Colombian government had. Since we don't have a lot of time, I would like to take the chance just to invite you to read this analysis that I wrote for the Oxford Business Law blog that is called Flattening the Filing Curve for SMEs, and that was published in a recent book called Covid-19 and Business Law. In this book, you will find analysis of various jurisdictions on how the governments have reacted in fields such as capital markets, corporate finance, and bankruptcy. So the words I will share with you briefly, I provide some more details in that text. And I encourage you to also visit the Oxford Business Law blog, where we're publishing weekly analysis on all these topics related to COVID.
Awesome.
I think from Colombia, what I can tell you is that Colombia is a civil law country. So in that sense, we share a little bit of what Joao was telling us. There's this culture of bureaucratic paperwork. We rely a lot on this type of evidence. And we like to think that is the nice way to frame it is that it's the country of laws, right? You have so much regulation that people are a bit obsessed with it. From the insolvency point of view, the first law was enacted in 1948. It used to be called the bankruptcy legislation, alluding to how you liquidate companies when they're no longer viable. But over time, it has changed, modernized until the current system that was introduced in 2006, called the insolvency law regime. And basically, as in many other places, the main purpose of the insolvency regime is to save viable business. And I think the viable is the key word here, because in the current circumstances, all companies have been struggling whether they have a viable business model or not. So the first challenge was to assess which companies is the system going to support and which they won't. And what an overview of the reactions in insolvency law around the world suggests is that most governments just try to save every company, even the ones that are not viable. And the way they did that is by eliminating, at least temporarily, the requirements to file for bankruptcy if you were under financial distress. But there's a second objective that is not analyzed as often of these bankruptcy reforms to confront the pandemic, and is to protect the system. So to prevent bankruptcy judges to just receive too many requests and not being able to resolve it. So the Colombian government introduced the first reform in April of the current year. My analysis is that it was an appropriate measure because it was fast and it tackled these two issues. So basically what the reform did is it created a presumption of financial distress. So since April 15, all companies are presumed to be under financial distress, and they no longer have this duty to file for bankruptcy. So with that, I think it was appropriate, and I think it was done in a similar way in different countries. I would be interested in knowing what my colleagues also have to say about this. However, that proved not to be sufficient, because what do you do with the government not having control on how companies are moving in the system? So a second measure that they introduced was to create an alternative system that is cheaper for smaller businesses to reach an agreement with their creditors. I believe that there are many details for which I believe it wasn't enough. Chief of which is to give authority to agencies that are not competent, don't have the same experience as bankruptcy judges to deal with these cases of smaller companies. However, I think the idea behind, the rationale behind it, I think is valuable. So we cannot give bankruptcy judges authority or encourage them to receive cases of all the companies that are dissolving to try to save all of them. As a temporary solution, I think it was appropriate. I think what the experience has showed is that even though the government has tried to support companies, the truth is that the impact of this pandemic, it just makes some otherwise viable businesses inviable. There's no market for everyone. So most recently, the government just last week enacted the last decree of these bankruptcy reforms, and I think it's a valuable effort also. I would be interested in knowing what's happening elsewhere. And basically what it is doing is giving the superintendents of companies authority to liquidate companies that are inactive for the past 3 years. So whomever wasn't already compliant with several legal obligations is presumed to be in financial distress. What I like about this measure is that by the end of this year, we will have a picture of which companies are actually surviving, which corporate debtors are trying to reach agreements with their creditors, and the government will have an updated, information on which companies they do need to support with other measures, and that the other measures I believe that need to be used is to facilitate agreements with the tax authorities. And this is a pattern that I see everywhere. That is that the tax authorities have not done enough to reach agreement with debtors that could recover if they could have their debt canceled, or if they could reach a restructuring agreement with the government. So that's all I have to say about insolvency. I have a couple of other comments on virtual meetings or corporate finance, but I think perhaps we can discuss that later on.
As you wish, because we are here in a time frame, so we're just gonna give a few moments for everybody. So if you want to add anything more, please, Mr. Alfaro, go ahead. So we can move on to questions if anyone actually has a question from the audience, or a few questions that we have here, and then we will give a conclusion. So please.
Thank you. So that was my first part on insolvency, that I think is at the heart of the regulatory reaction to the pandemic. I think a second area that experienced positive changes is virtuality. So for a moment, as Christina was telling us, governments have sought to facilitate remote meetings, whether to go to hearings in the judiciary or within the corporation. And a positive thing that happened is that finally, corporations were allowed to have the shareholder meetings virtually. It was a famous case in the United States by the end of June, where over 100 shareholders gathered in a shareholder meeting, and there was a contest on board election that I think went quite well. But I think it opens up new avenues of reflecting how are we going to conduct these meetings. In Colombia, we had one with 1,000 shareholders. It was a private company, so it wasn't on the media, but it proved to be good. I want to highlight this because over time, the arguments against virtuality were dual. On one hand, it's too expensive. We need to set up a sophisticated system that is reliable. And on the other hand, people are going to cheat, are going to do things, behind the scenes. And what this proved is that none of them is actually true. We can use platforms like Zoom that are free. People are actually more willing to participate. Shareholder participation went up. Shareholders tend not to go to these meetings because they're burdensome. And in this case, we had a shareholder meeting with almost 1,000. You can log in from your house. So insolvency, virtuality, and finally, corporate finance also experienced some improvements because the government, as Andre was saying, most governments have been given special powers by the legislative. The way that you said, though, I think that's something we have to be very careful on. In the case of Colombia, I think one reform that I was waiting for was to allow smaller businesses to raise funds in the stock market. And that just happened last week after 10 years of academics and practitioners trying to lobby the government. And I think that will be very helpful for the few small businesses that are able to survive the pandemic.
Awesome. Thank you. Muchas gracias, Mr. Halfon. Thank you so much. I really appreciate that. And I really just want to talk about myself. I really learned a lot about the bankruptcy, you said, because of last week, our government just barely legislated that bankruptcy law. So it's something for us. It's kind of different and new. And as also Mr. Isaac said about how the courts were opening state by state. Well, I think safe to say that thank God that Kuwait is actually really, really small country that when it's open, we only have like 6 courts probably or 7 at the most. So it opens all at once. So please, anyone of you want to add something more, a comment on what Mr. Alvaro Herrera said? Yes, Mr. Papa, please.
I just wanted to add to what Alvaro said about the bankruptcy and insolvency issues, especially in India during COVID-19. What happened was the government imposed a total lockdown, so there was no economic activity whatsoever. All private establishments were shut down, except for essential services like power, banking, internet, and food and transport and all of that. There was no public transport and there was no economic activity whatsoever. So obviously there were a lot of issues of job losses, loan repayment issues, bankruptcy and insolvency proceedings going up and all that. So what happened was the government actually came and said for the period of the lockdown, which was about 65 days, you cannot initiate insolvency proceedings against any company ever if they have not been able to discharge their admitted debt or liability. In addition to that, what they've done here is to sort of exclude the time frame of the lockdown for all the compliances that insolvency resolutions professionals were supposed to do under the code. So that's how here they've dealt with the issue of insolvency proceedings. And I take it from Alvaro that there has to be a distinction between viable companies and companies that are not viable. And this is a blanket step that the government has taken without making that differentiation necessary. So I think we're going to have a lot of companies that are going to be around even though they're not in a position to discharge their debts or liabilities. That's one. And with respect to job losses and loan repayment issues, the central government actually tried to come up with notifications to state that you cannot fire employees, you cannot reduce their pay, you cannot even defer their pay even during this total lockdown. That was ultimately challenged before the Supreme Court and the matter is pending consideration, but the government has withdrawn that notification here. But for that 50-day period for which that notification was in force, the parties still have to figure out how to arrive at that settlement between themselves. And with respect to repayment of loans here, the Reserve Bank of India has provided a moratorium of 6 months to make sure that people who are affected by the lockdown, who lost their jobs, who lost their incomes, they're not sort of driven to the brink of bankruptcy, personal bankruptcy. So they've been given that holiday for a period of 6 months, but in that period, they've still charged interest on the outstanding and interest on interest, which is again challenged before the Supreme Court and is pending consideration. So I think these issues are common across the board because of the effect on the economy. And from this panel, I very recently learned that, if there are cases that are increasing, there are lots of disputes that have arisen as a result of COVID and the lockdowns and all of that. But insofar as courts are functioning, there is going to be a lot of work. But if courts are not functioning at full capacity, then there is some kind of a bottleneck that we have to deal with at some point. So it'll be interesting to see how we deal with those bottlenecks, especially with adding capacity for virtual hearings to sort of get back to court activity at pre-COVID levels.
I see. As actually Mr. Abdurrahman Al-Tahouz earlier, he mentioned he talked about this specific things, especially with employees. That's why the government of Kuwait actually supported law firms owners first of all, they said you don't own any bank or you don't own any payments for a period of 6 months. 6 months, whatever you make an income, it's all for you. Second of all, for 6 months, they paid the salaries. It's actually from the government. So you won't fire any employees or reduce the salary of it. So if you have, let's just say, an employee who takes $600, so you cannot just give him $300 and say, hey, it's a crisis right now and I cannot do that. Or there you go, you are fired right now. And they won't allow that. That's one thing that I will hold dearly for our government to do so. And the second thing is what our courts actually also did for the rental law and issues, that you cannot evict in this period, no matter what. Even the payment, they put some regulation actually for few rental bills, that some of them that you have to waive or postpone or reduce 75% of it. And in the long term, you will get compensation. But for now, you cannot just do that just for the sake of the economy, of those small businesses or law firms or those companies. So thank you so much for that, Mr. Babu. And anyone else want to add something, please? Or any questions from our audience? Yes, please, Mr. Isaac.
Unmute. I would just like to ask a question of fellow panelists. Just, do you think that the pandemic has changed, significantly changed things, for example, that say this governments, states, the legal systems were not really thinking about? Or do you think it accelerated the changes that were more latent and it just forced us to shift faster? So for example, on the virtual side of things here, one judge, for example, told me, we always thought about going virtual. This pretty much made us, again, with the exception of the jury trials. And he said this is going to change forever the way we do operations in the courts moving forward. So I'd just be curious to what everyone thinks in their respective area of law, what the case is.
Awesome. Can I please transfer this also for Mr. Abdurrahman? أستاذ عبد الرحمن، السؤال من مستر ايزاك قال إن شلون راح تعتقد شنو التحديات اللي راح تصير أو التغيرات اللي راح تطرأ علينا، مثل ما هو تناقش على قولته مع جدج أو واحد من القضاة، قال إنه إذا تمت الأمور على موضوع مثل موضوعنا الزوم هذا، إذا بلشوا فيه راح يغير الأمور مجرياتها إلى الأبد. يعني احتمال، وأنا هذا من رأيي أنا، هم قلنا احتمال إذا شافوا الأريحية والسهولة في هذا الأمر ما راح يرد الأمر مثل ما كان عليه من قبل كحضورك أنت ولا كيت، فيخلون الأمور في السلاسة والسهولة اللي هي ماشية. فهل هذا راح يصير؟ تتوقع حاصل ولا؟
بالضبط. طبعا اتفق مع كلامه 100%. يعني النقله النوعيه اللي راح تصير في قطاع المحاماه عندنا، اقول لك بالتحديد بالكويت، راح تكون جميع الامور عن طريق التكنولوجيا. اذا احنا حلينا الامور امام ادارات الدوله اللي هي اداره التنفيذ وبالمحكمه، اعتقد تحتاج تعديل بعض القوانين البسيطه اللي من خلالها راح يصير التعامل مع الموكلين، وراح يصير التعامل مع الادارات القانونيه كلها عن طريق الاونلاين وعن طريق الالكتروني. هذه نقله نوعيه يجب ان تكون خلال المرحله القادمه، سواء يعني احنا هذه قلت لك انا جائحه كورونا كشفت لنا تسلل وخلت لنا يعني احنا نعمل على تعديل هذه القوانين. ف يعني اعتقد واتفق مع الاستاذ ان راح تكون هناك يعني نقله نوعيه راح نستمر معاها.
ولكن شنو دور المحامي استاذ عبد الرحمن تالي بعدين؟ خلينا نتكلم بخصوص مثلا اذا فعلا مثلا حصلت وصار الامور مثل ما تقول انت مرئيه، انت باكر قاعد بمكتبك ما تنزل، او بالاحرى عادي قاعد مثلا بالبيت وعندك هيرنج على قولتهم او جلسه وانت قاعد تحضرها كاشف.
طبعا استاذ
الدور هنا راح يختصر ويقل شويه في امور اعتقد ان فيها سلبيه خفيفه.
لا ما بالعكس ما فيها نهائيا، فيها كثير من الايجابيه. اليوم المكاتب الاجنبيه بالكويت هذا عملها، ما تجتمع مع الموكل الا بالفتره النهائيه في مرحله اعداد كامل القضيه هني تجتمع مع الموكل، ولكن جميع الاجتماعات اللي تسبق هذه الامور وجميع المستندات تقدم عبر الاونلاين وتنتهي عبر الاونلاين. فبالتالي
في نقطه ذكرها مستر ايزاك، قال ان من المؤسف والمحبط بعض المرات ان الموكل مالك ما تقدر تشوفه على قولتهم اي تو اي، you cannot see your client. يعني ما تقعد معاه، شلون تبي يكسب الثقه؟ شلون انت تبي تعطي الثقه من خبرتك انت اذا كان بس الامور مثلا سواء مرئيه او بالتلفاز يعني بالكاميرا؟ شلون؟
طبعا احنا يعني كمجتمعنا بالكويت وطريقه تعاملنا مع الموكلين هي تعتمد على السيره الذاتيه للمحامي. فبالتالي هو يعتمد السيره الذاتيه سواء للمكتب او للمحامي نفسه في طريقه تعامله. ممكن حتى لو انا ما اقدر اشوفه، ولكن انا قاعد اقدم له الجوده في العمل. يعني اليوم خل افرض لك يعني هذه اعمال نقوم فيها بشكل يومي، في بعض العقود توقع بين طرف وطرف اخر ينجزها المحامي عن طريق الاونلاين وعن طريق المراسلات عبر الايميل وعن طريق حتى يعني بالفتره السابقه اللي هي الاجتماعات البسيطه على برنامج زوم. فبالتالي لا انا اقدر انجز انا عملي اذا توقع العقد بين الطرف والطرف الاخر وكان هذا العقد محكم قانونيا، هني صدقني راح تكون الثقه كامله بالمحامي، راح تنبني الثقه للتعاملات المستقبليه.
نعم شكرا استاذ عبد الرحمن، يعطيك العافيه. Well, Mr. Abdurrahman actually said he thinks about your question that it's going to be a huge jump and a huge change, especially with us here in Kuwait, because right now actually we don't do anything electronics whatsoever. We not everything, but mostly we can take the simple documents from the computers, the system, but we cannot submit our memos to the judge. We cannot do that. We are missing a lot of things. So he thinks it's a really huge positive thing that if it's happened. So we raised a question. If we said if everything went virtual, if the judges got really comfy about that, and what's the role of the lawyer later on? So you just sit in your office and your home. Okay, maybe you can dress up for your hearing and you all look nice on the camera and you never step on the court again. For me, I'm not gonna take or say my personal opinions. I'm just trying to raise some questions. But I think this is one of the maybe slightly negative things that might happen if everything completely went technological and virtual. And what's the role of the lawyer in the near future? So please, anyone. Yes, Christina. Miss Christina.
Okay. I think we have some positive issues here related to the virtualization and the digitalization of documents in the courts. In Brazil, that was a reality before. And to be honest, I don't think even pushes further, because all the major, all the main courts in Brazil, it started to start this process of digitalization, and all the processes are being virtual. So I think this proves that we were on the right path, that it was actually a good option of doing this from the beginning. But I'm also very worried if this will be the future relating to hearings and trials. Some lawyers in Brazil, they believe so. Some others, they don't. We lost, in some cases, the opportunity of being part of the oral arguments. So I believe, at least in the Brazilian Bar Association, the lawyers will, after all of this, try to shift a little bit more to the actual presence, and some acts and some trials and hearings. I believe that in a most general way, the lawyers and maybe also the National Justice Council, they will bring it back, the physical and the presence hearing, not doing everything remotely. But a lot of lawyers are really worried if this is something that will be kept going. And I honestly, I don't see the role of a lawyer outside the court. So it's actually some uncertain times.
Well, thank you so much. Sorry about that. We have a few technical issues. This is one of the technical issues that we're talking about here in Kuwait. So, and Mr. Isaac, please. We would, Mr. Andre, yeah. Just because they raised the question, I thought he might want to have a response for that. Mr. Andre?
Yeah, also Alvaro was the first, right? Would you like to speak first?
I'm so sorry. I'll go back to you as well after Mr. Andre.
Okay. So I believe that the role of lawyers will be huge in the near future, because I believe that we are on the verge of huge constitutional challenges and changes. And I completely agree with Isaac, who raised these points, because there are a lot of new areas where lawyers can work, and there are a lot of new fields of law that are still not very developed in many jurisdictions. As you mentioned, that, for example, that in Kuwait has recently enacted the bankruptcy law, just because bankruptcy has never been an issue in Kuwait. There are fields of personal data protection, privacy, IP rights, digitalization rights, digital signatures, and so on, and digital identity. And these are fields will be they should be reflected in the constitution in this or that way, either directly in written constitutions or indirectly by way of precedent. So lawyers will move from the areas where, like tangible assets were an issue. They will move into the areas where intangible assets become value. So lawyers will elaborate these policy considerations with these policy principles, these approaches, and articulate them. So my opinion is that the work for lawyers, this will be, it's huge. I mean, this field is huge, and we have a lot of things to do in the near future. And my opinion is that the COVID, yes, it brought about these changes, and these changes were quite latent. I believe that even without COVID, we would face these changes and challenges in the near future. So perhaps I know this maybe sounds weird, but thanks to COVID, we are now facing it right now, not in 2, 3, 5, or 10 years. So my opinion, bottom line, that the work for lawyers will be more complex, more complicated, more difficult, but more interesting, and this work will be quite enough for us all to do with.
Thank you. Thank you so much, Mr. Andre. Mr. Alvaro, we have 10 minutes. I can push it to 14, 15 minutes, and we should have our conclusion. Mr. Alvaro.
No, thank you. No, I want to second what Andre said, and just add that many of the changes that we are seeing are things that were expected. So before becoming a full-time academic, I used to be a corporate litigator, and one of the challenges that we had was that, at least in Colombia, I know this is the case in many countries, the main judiciary for corporate disputes tends to be in the financial center. So for corporations that are located elsewhere, litigating is costly. You have to hire lawyers that tend to be more expensive in the financial centers, and you will have to travel there when you have to practice evidence and so on. This just deterred litigation. And in the alternative, what used to happen is that parties resorted to arbitration, which in my view is a complement, not a supplement of regular judiciary. So what has happened, and I think this is very important both for lawyers and for the quality of the legal system, is that it's become cheaper. So in Colombia, what we experience, me from the distance, what I witnessed, is that because now you can have a virtual hearing, you can have smaller companies that perhaps had issues that were never litigated before, having access to justice cheaply. That they don't have to travel, they don't have to hire lawyers elsewhere. And I think this is good for the lawyers. And we have lawyers all around the country becoming more sophisticated in these topics. You have minority shareholders in smaller corporations, protecting their interests. And also the quality of the legal system improves because you have a higher volume of cases that is allowing judges to develop a case law that is better for everyone. So in my view, this forced transition, if you will, can have some of these positive externalities in just helping the system to improve and giving more opportunities for lawyers to participate.
Thank you. Thank you so much, Mr. Alvaro. Yes, Mr. Babu, please.
The microphone is still.
Yeah. Try it right now.
No, I think I'm still activated. Yeah.
Oh, there you go. Thank you.
Thank you, Mr. Mohammed. One thing that you said really struck a chord. What is the role of a lawyer? And if you're not going to be in courts, I personally miss it. I personally miss being in court with my uniform, and I think we're a lot more effective when we're arguing in courts as opposed to doing it over video and a laptop and all of that. But having said that, and another thing that really makes a difference is when we started out, we were told that even if you have no work, even if you're free for a day, go sit in a courtroom and watch a proceeding, just to understand how a judge thinks, how different matters are taken up, and there's a lot of learning in that. I think that is something that we will miss when things go completely virtual. Except now, courts in India are open to the possibility of allowing for public access to court hearings. What Christina was mentioning already happens in Brazil. That's great to hear. And to Mr. Isaac's question, the very valid questions, thank you for raising them. And I think my personal view is that these are changes that have always been in the works, and most countries have been dealing with these issues at a slower pace all these years, and now we are pushed to sort of improve and put these things at a much quicker pace. But just to take an example that you gave out as to jury trials not being able to take place, and all the issues that are there in a system like that. Those are the kind of issues that we are facing here as well. Recently, the Supreme Court took up so much cognizance of overcrowding of prisons during the time of COVID-19, and they came out and gave a list of recommendations that the government has to follow to decongest prisons. One, and most importantly, they said now under trial prisoners don't need to be in court every time their matter is listed for a hearing, which was the norm before. I think we're going to see some of these reforms taking place, and what How mentioned about a lot of people not having access to bank accounts, internet, high-speed internet, to be part of hearings or to be part of this process. Those are issues that we'll have to raise. And I would like to take something from what Andre said about, you're going to have privacy issues, you're going to have data protection issues. Some countries, I think Finland has said that internet is a fundamental right. Some of us are not yet there yet. I think the way that we approach these issues is going to create a lot more issues for lawyers to work with. And I think there is always going to be work for good lawyers, except if we can navigate issues of access to justice and courts being operational, I think lawyers will always have a lot of work going forward. Thank you.
Thank you. Thank you so much, Mr. Papo. I really appreciate that. Anyone have their final comments or something to say? Okay, for a conclusion, I just want to say one thing, which I actually read, and I completely stole from McKinsey's magazine, and I really liked it, just for what we have facing right now in this crisis, how the COVID-19 affected us, just how we're supposed to actually treat each other. Everyone is actually going through a lot of things, small businesses, big businesses. It just, we need to work. And it actually says your people are your law firm. And I really like that phrase. It's whoever actually is working with you, acknowledge and deal the humanitarian and personal elements of the COVID-19 crisis with empathy, support employee flexibility, collaboration, and connectivity through technology and frequent communication from firms' leaders, which I really hope everyone does. Look for opportunities to relocate and access capacity rapidly toward building new firm capabilities or pro bono activities. Every firm member should see clearly how their work is meaningful through this period. This is what I have actually to say for this, and I really, really, really thank you all for taking the time to join us here. And on behalf of everyone and Mr. Abdurrahman, my colleagues, thank you so much. I'm really honored. I gained a lot of knowledge and information from each and every one of you. I really appreciate you. Thank you so much. افتح المايكات كلها افتح المايكات. We're just gonna open the mics right now, everybody, so we can say our farewell. No, we hopefully will keep in touch with everybody, so we'll exchange our emails and everything.
Thank you very much for the invitation and all of you for your comments.
It's a pleasure. It's a pleasure, really pleasure.
Thank you so much, Mr. Mohammed. It was a pleasure being here tonight. I talked with Fawaz prior to the webinar, and for sure, I think we're gonna we can talk in another debate about elections. He told me that Kuwait is going this year in elections.
True.
The U.S. is also, and in Brazil we're going also.
I'm really interested in the U.S. election.
In Brazil we're also going, so we also, the technology will have to do some advances here in the electoral process. So maybe next time we can talk about that, but I'm very happy with the invitation and the opportunity of learning from different experiences through this delicate time. Thank you so much.
Likewise, thank you so much. I really appreciate it.
Thank you. Thank you for the invitation.
Thank you. Thank you, Mr. Mohammed, for the invitation.
Thank you. Shukran.
Thank you so much. Thank you. I really appreciate that. Thank you.
Thank you, and I hope we can all stay connected for future debates.
Well, we will. I'm going to make sure that we will, because I'm going to get more heat-up topics next time, so we will argue more. As much as I love to argue in front of a judge face-to-face, not on camera. So thank you so much, and have a good night, everybody.
Thank you. Good night. Thank you. Bye-bye.
Bye-bye.